This interview is a fictional reconstruction created for educational purposes only. It does not represent real events or individuals. Nothing in this content should be considered legal advice. For legal guidance, please consult a qualified attorney. Artificial intelligence was used to generate portions of this material.
Good afternoon and welcome back to Legal Matters, the show where we make legal topics clear and easy to understand. I'm your host, Sarah. Before we begin, please remember that this program is for educational purposes only. It is not legal advice. If you have a specific legal issue, please consult with a qualified attorney. Today we're discussing two closely related topics in California civil law, battery and assault. Both can be the basis for a civil lawsuit, and while people often use these terms together, they are actually distinct causes of action. Joining me to help explain the difference is Professor James Whitfield. Professor, thank you for joining us.
Thank you, Sarah. It's a pleasure to be here.
Let's start with battery, since that's the one most people associate with physical contact. Can you remind us what civil battery means under California law?
Of course. In California, civil battery means an intentional and unwanted touching of another person that is harmful or offensive. The key word there is intentional. The plaintiff, that's the person suing, must show four things. First, that the defendant intentionally touched them or caused them to be touched in a way meant to harm or offend. Second, that the plaintiff did not consent to that contact. Third, that the plaintiff was actually harmed or offended by it. And fourth, that a reasonable person in the same situation would have also found that contact offensive. So it's not about accidents, it's about deliberate, unpermitted contact that violates personal dignity.
That's really clear. So it's not just about being hit or injured. Even an offensive touch could be considered a battery.
Exactly. California law says even the lightest touching can be battery if it's done in a harmful or disrespectful way. For example, pushing someone out of annoyance, spitting on someone, or throwing a drink could all qualify as battery if they're intentional and unconsented.
Now, before we move on to assault, could you touch on the main defenses to a battery claim?
Certainly. The two most common defenses are consent and self-defense. If someone consents to being touched, like in a sports game or a medical procedure, that contact is generally not a battery. But the contact has to stay within the limits of that consent. If it goes beyond what was agreed to, it can still become battery. The other major defense is self-defense. If a person reasonably believes they're about to be harmed, they can use reasonable force to protect themselves or another person. The key word, again, is reasonable. The force must match the threat, not go beyond it.
So a little shove to protect yourself might be okay, but hitting someone repeatedly after the danger is over wouldn't be considered reasonable.
Exactly. The law measures reasonableness by looking at what an average person would do in that moment.
That's really helpful. Now, let's turn to assault, which is often mentioned alongside battery. What does California law say about assault as a civil claim?
In civil law, assault is not about the physical contact itself. It's about the threat or attempt to make that contact. The California civil jury instructions, what lawyers call the CACI, say that to prove assault, the plaintiff must show several things. First, that the defendant acted intending to cause harmful or offensive contact, or at least intending to make the plaintiff believe that such contact was about to happen. Second, that the plaintiff reasonably believed they were about to be touched in a harmful or offensive way, or that it reasonably appeared the defendant was about to carry out that threat. Third, that the plaintiff did not consent to that conduct. Fourth, that the plaintiff was harmed, often by fear or emotional distress. And finally, that the defendant's conduct was a substantial factor in causing that harm. So, to put it simply, assault is about creating the fear of immediate harm, while battery is about the harm or contact actually occurring.
That's a really clear distinction. One is about the threat of contact, and the other is about the contact itself.
Exactly. You can think of assault as the attempt at battery or the threat of it. The tort of assault is complete the moment the person reasonably believes they're about to be touched in a harmful way.
So if someone raises their fist as if to hit me but doesn't actually strike, that could be assault?
Yes, that's right. If it reasonably appears that they're about to carry out that threat. The law focuses on whether the plaintiff had a reasonable apprehension, meaning a reasonable belief that harm was imminent. But it's important to note that words alone don't amount to assault. Someone saying, "I'm going to hit you," without any action that makes it seem immediate usually isn't enough. There must be some physical act or gesture that creates a real and present fear of being harmed.
That's interesting. So the law looks for an immediate threat, not just a future one.
Exactly. Assault is about the fear of being touched right now. If the threat is for something that might happen later, that's not assault under civil law.
What about intent? Does the defendant have to actually want to harm the person?
Good question. The intent in assault is very similar to battery. The defendant must act with the intent to cause harmful or offensive contact or to make the other person believe that contact was about to happen. It's not necessary that the defendant actually wanted to injure the plaintiff. It's enough that they meant to cause that fear or expectation of harm.
So to summarize, assault is when someone reasonably believes they're about to be harmed, even if they're not actually touched. And battery is when that contact actually happens.
That's exactly right. Assault protects the right to live without being put in fear of personal harm, while battery protects the right to be free from unwanted contact itself.
Are there also similar defenses available for assault, like in battery cases?
Yes, the same general defenses apply: consent and self-defense. If the plaintiff consented to the behavior, or if the defendant was reasonably acting to protect themselves, those can be valid defenses to assault.
This really helps make the distinction clear. Assault is about the fear of contact, and battery is about the contact itself, but both protect personal dignity and safety.
Exactly. Together, they cover both the anticipation and the occurrence of harmful or offensive contact. That's why they're often discussed side by side in California law.
Professor Whitfield, this has been an incredibly helpful discussion on both assault and battery. Before we wrap up, do you have any final thoughts for our listeners?
Yes, whether it's assault or battery, these civil causes of action exist to protect people from unwanted contact and the fear of it. And as always, anyone considering a lawsuit should seek advice from a qualified attorney who can evaluate their specific circumstances.
Thank you so much, Professor Whitfield, for breaking this down for us.
Thank you, Sarah. It's been a pleasure.
And thank you to our listeners for joining us on Legal Matters. Remember, this program is for educational purposes only and not legal advice. For guidance about your own situation, please talk to a licensed attorney. I'm Sarah, and I'll be back next week with another topic to help you better understand the law.